Most people think they're supposed to choose between a trust, a will, and a beneficiary designation, that one thing is more superior than the other, and they've got to choose just right or their family is going to be devastated. Now, that's not true. Let's talk about why. The truth is, whether it's a trust, whether it's a will, whether it's a beneficiary style deed or a beneficiary designation, they're all just unique tools to accomplish a specific goal. And it's not unusual for someone to have all three. Now let's start with a will. Most people are familiar with a will at this point. It's instructions for a probate judge that says who gets what when you pass away. Yes, a will goes through probate court. Big misconception that it avoids probate court. It is not true. It's instructions for a probate judge for who gets what, how that should happen. Now, in some states, like Texas, probate's generally not as big of a deal. With a good will, your family's not going to have that much pain getting through the process. In other states, like California, you really want to avoid probate for your family. Now, just about every adult needs at least a basic will that's going to say, if I pass away and there's something in my name, here's who should get it, here's how it should happen. Yes, that's going to go through probate court, but at least your wishes are known, and generally it's going to make the probate process at least more clear, if nothing else. Now, in my opinion, it's a little silly to stop at a will with all of the planning tools and opportunities we have available today. Even in a state where probate isn't so bad, it's still going to be wasted time and money and a headache for your family down the line. So everyone needs at least a will to make their wishes known, but what if one of your goals is to keep your family out of probate court and allow them to settle your affairs around the kitchen table instead of in court? Well, the first thing that we'll look at then are beneficiary designations. It's a simple solution to keep families out of court. If you have beneficiary designations on everything you own, then there's nothing left for the will to actually control, because there was nothing left in your name without a beneficiary designation. Yes, beneficiary designations override a will. And just about every type of asset nowadays you can have a beneficiary designation on, whether it's a pay on death or transfer on death beneficiary. Checking, savings, brokerage, life insurance, retirement, vehicles, you name it. And yes, even real estate. You'll see it referred to as a transfer on death deed or a ladybird deed in a few select states. You list your beneficiary, and as long as your beneficiary survives you and goes through the proper steps to actually claim the assets after you pass away, before anything else happens to them, we stay out of probate court and we transfer the property according to your wishes. So plenty of people will have a will that's acting as a safety net just in case something slips through the cracks, but they're really leaning on beneficiary designations to do most of the work and transfer everything to the people of their choice. Now, what if your goals include not just simple probate avoidance, but something a little bit more? Well, that's likely where a trust is going to come into play. You'll hear different words for it, but what I'm talking about here is a revocable living trust, also known as a family trust or just a living trust. Now, this is very similar to a will. It says who gets what, how that should happen, but it takes effect while you're alive instead of after death through the probate courts. And as long as we set it up properly and you have the proper counsel along the way, something were to happen to you, there's no downtime for your family. They don't have to go to court and get a judge's permission. They just open up the trust, read the instructions, and then start carrying out the wishes. Now, you don't do a trust just for probate avoidance. If someone's selling you a trust just on the grounds that it avoids probate, they probably don't know what they're doing. Now, a trust can be a very powerful tool if your goals extend beyond just simple probate avoidance. And for everyone, that may be a little bit different. It may be that we want to have detailed contingency plans around if this person passes away before me, where does their share go? And when their share passes to that person, how will it then be inherited? Or for the primary beneficiaries, do we want them to inherit at a certain age or at certain milestones? Do we want to incentivize certain activities or make more of a morals-based inheritance? Do we want to protect against infighting and lawsuits amongst beneficiaries after they inherit? Do we want to protect a beneficiary from themselves when they have spending problems or addiction problems? Or do we want to protect them from outside forces like creditors or divorce after they inherit? Or do we want to create a legacy that extends beyond just one generation? Those are all things that a trust is great at, but the key point here is whether it's a will, whether it's a beneficiary designation, whether it's a trust, there's not one that is better than the other. You may have all three. You may have a will that's acting as a safety net and nothing more. You may have beneficiary designations that name either people or a trust as your beneficiary, and you may have a trust that adds extra contingencies or protections and optimization around the inheritance. Now, what's right for you? It depends. Depends on what your assets are and what the goals and wishes are for those assets, what the family dynamics are. There's a lot that go into deciding the right structure for your family. Having a conversation with an expert estate planning attorney in your state is crucial to deciding what may work best for your family. For more estate planning tips from an actual estate planning attorney, follow along and drop your questions in the comments.